To do a Q&A with the co-directors of the Division of Enforcement at the SEC, Stephanie Avakian and Steve Pekin. Stephanie began her first tour of duty at the SEC in 1995 in the New York Regional Office, where she rose to be a branch chief and then became counsel to former Commissioner Paul Carey. After leaving the SEC, Stephanie went to work at WilmerHale, where she was the vice chair of WilmerHale's securities practice, and where I think many of you had the opportunity to work with her on the defense side. My experience with Stephanie is when there was a large group of people, Stephanie always stepped up to take the lead and keep us all organized.
Bossy.
In 2014, Stephanie left WilmerHale to become the deputy director of the SEC's Division of Enforcement. In the change of administration, became the acting director, and last June, she and Steve were appointed as the co-directors. Steve came to the SEC for his first tour of duty last June from Sullivan & Cromwell, where he was the managing partner of the Criminal Defense and Investigations Group. Steve tried many and defended many high-profile cases at Sullivan & Cromwell. He came to Sullivan & Cromwell after a tour of duty in the Southern District U.S. Attorney's Office, where he ended his career as chief of the Securities and Commodities Fraud Unit. And we are very grateful that both Stephanie and Steve are joining us today. Given that this is a room full of criminal defense lawyers, we thought a good starting place might be, why do some fraud cases end up only being civilly handled and others become criminal? What's the process? What do we anticipate the ingredients are that leads to a criminal case?
And I think it's lots of different things. We're pretty thoughtful about it. Look, there are some cases that you know pretty quickly, and you can look at the conduct and you know it's criminal in nature, right? I mean, a lot of insider trading cases can fit that bill. Ponzi schemes, some of the affinity frauds we see, there are some schemes that you sort of know quickly. There are also some, I'd say, cases where it's obvious that really only criminal remedies are going to stop the person, right? Like we see a lot of recidivists, particularly in the penny stock world, doing these pump and dump schemes and things like that. Cases like that, I think, are pretty easy. And then some, it's really, I'd say, as we go through the investigation and kind of see where the pieces are going, if there are issues that we know different criminal partners we work with have particular interest in and things like that. So, I mean, I'd say sometimes, up front, a lot of times it's really through the development of the evidence that you start to think this really does feel more criminal in nature than not. And so, I don't know if you have anything to...
We're big believers in the effectiveness of the criminal involvement for reasons that Stephanie said. And so, they're a force multiplier for us. They provide remedies and relief that, deter people in ways that nothing we do could ever deter misconduct. And so we're asking on the front end in every case that, gets opened, we're reading the opening documents, whatever it is, a request for a formal order of investigation or whatever, with an eye toward, is this something that there should be a criminal authority involved in? And I think we fairly frequently will go back to the staff and say, have you thought about referring this to somebody? Yeah. So, we're hoping that a lot of what we do, when appropriate, will have a parallel criminal investigation as well.
And how does that referral to a criminal authority take place? Is that formal or informal?
I don't think we have any kind of informal or formal referral process. Typically, we pick up the phone and call somebody and say, there's a matter. We might describe it to them in general terms and say, you may want to put in an access request. And then we'll share, whatever's in our investigative file. And then there will be, a dialogue that ensues from that. So there's not, I guess that's a pretty informal process. There's no action that needs to be taken by the commission or formal approval authority for, by us. A lot of times by the time, we'll ask the question, it's already taken place. They'll say, we're already working with New Jersey on that.
Mm-hmm. When I started out in this business, there was actually a formal criminal referral, which the Enforcement Division would write a report, the Office of the General Counsel would sign off, and the Commission would vote. But I gather, given time pressures, there are no longer any formal referrals?
I'm not familiar with the process, so I'm either not following it or it doesn't exist. Those are the choices.
The Kokesh case came down recently, and I guess the time pressures that you're under as a result of that would make a formal referral process more difficult.
I mean, Kokesh, there's no doubt that Kokesh is important and is going to have a big effect on the program, and we've said that. But Gabelli came down a few years ago. I mean, I think we've long been operating under the working knowledge that we've really got, 5-year statute of limitations with which to be able to get a penalty, now disgorgement. And so I'm not sure Kokesh has really changed anything in terms of when we make the decision to refer. There's no doubt that it, is another reason to bring cases faster and do investigations faster.
Steve said you pick up the phone and suggest that someone puts in a request for access to your files. How do you decide who to pick up the phone to? Federal, state, which district?
So I think, it depends obviously on the facts and circumstances. Sometimes the geography of the conduct, draws you to a particular location. Yeah. Sometimes there are people we've worked with on particular issues or kinds of cases. We know they have the expertise and the interest and the resources, so we'll call them. It's not just, contrary to popular belief, it's not just Main Justice in the Southern and Eastern District of New York. We're working with lots of U.S. attorneys' offices around the country. We also sometimes make referrals to non-federal authorities. Yeah. Sometimes the kind of conduct and the dollar value is such that it might not really meet whatever threshold a U.S. attorney's office might have, particularly in a smaller district. It may make more sense to call the state AG or a local prosecutor instead of the U.S. Attorney's Office, and we do that with some frequency.
Once a criminal prosecutor is involved, how do you decide whether the investigation is going to be a joint investigation or a parallel investigation? I think there's some confusion in the defense bar as to what those words mean.
Well, I think we take the view that there is no such thing as a joint investigation. Unfortunately, some courts have disagreed with that view and deemed our investigations to be joint. But we, and I think the criminal authorities, are studiously trying to conduct parallel investigations in which we're each making decisions based only on the interests of our agency, not in the interest of promoting somebody else's agenda. There have been some decisions, particularly in the Southern District of New York, that have said, well, you're doing interviews at the same time, you're bringing charges at the same date, et cetera. Those sound more like joint investigations to me, and so therefore I'm going to require that your files be reviewed for exculpatory information, for example, or documents that are in the possession of the SEC will become discoverable under the criminal rules. I think both the criminal authorities and the SEC have resisted those, sometimes with success and sometimes without success. I don't know if you have a different thought.
No, I think that captures it.
So in terms of Brady obligations, disclosure obligations, so it would generally be your view that they're not applicable to your investigations absent some determination that it's a joint investigation rather than a parallel investigation?
Yeah, I don't like to think that we're aware of flaming exculpatory information and we, through some formalistic method, are sitting on that. I think it's pretty unusual in an investigation for exculpatory information, material exculpatory information, to find its way to us and not to the parallel criminal authorities. So I think it would be pretty unusual for us to be in sole possession of something that's, Brady material.
Grand jury secrecy, does this become a problem for you in parallel investigations?
I mean, obviously we don't typically have access to grand jury information, so it's not a problem in that respect, right? I mean, the exceptions would be occasionally we'll have somebody from the SEC become a special assistant U.S. attorney or something like that, and then they'll go over to that side and be subject to the same secrecy requirements.
And walled off from your
And
side.
walled off, exactly. But in the normal course, that's not something, we don't have access to that information.
On the parallel proceedings, there are often motions to stay the SEC action pending the resolution of the criminal case. Is that a case-by-case decision for you as to whether to go along with the motion to stay, or do you have a policy on staying SEC cases when there's a criminal indictment?
Yeah, our policy is typically to not take a position. The motion is by the U.S. Attorney's Office. We typically don't take a position. Sometimes we may need to for different reasons, but typically don't. When the motion is not one of the government's, we may take a position, but I would say typically our policy is not to.
Moving on to the international front, I think David Green, the head of the SFO, is doing the keynote address here tomorrow, and there's a lot of interest in international cooperation. It seemed as if there was an arc of regulators cooperating more smoothly and more regularly for quite a while. A question has come up with the rise of nationalism, Brexit, and other developments in Europe and around the globe. Do you see international cooperation changing? Any discernible differences in the last year or two?
I don't think so, and I think that sort of trajectory continues to be an upward one. And if you look, the place that it's most obvious in, it's not the sole place, but in the FCPA space is the one where it's most tangible. And if you look through the FCPA cases that have been brought in the last, whatever period, year or so, they reflect, very close and I think, first of its kind cooperation with all kinds of sovereigns. Not just in Europe, but in Latin America and elsewhere. I think there's still work to be done, but I don't think we've seen a cooling of cooperation. No. And those pathways are, once they're trod and the path is broken, I think there's even more free flow of information. So, in the Telia Sonera case, we worked closely with the Dutch authorities. We had done that in a previous case, and so I don't see a decline.
I totally agree. I think it's only getting better and more frequent. And we also, even when we're not doing sort of parallel investigations, we assist each other. And the number of requests we're getting from foreign authorities for assistance and the number of requests we're making to foreign authorities has just increased over the years, and I think will continue to.
As there are more and more authorities looking at conduct that overlaps, is there some way that the defense bar can try to come to global resolutions in which they can negotiate with a group of regulators, including yourselves, what the overall payment will be, rather than settling with one and then maybe being whacked or maybe not being whacked by another? Is there some hope that the cooperation will lead to more global resolution discussions?
We certainly are very amenable to that, and we've participated in those conversations and we've participated in those negotiations. We obviously can't control the rest of the world.
Try as we may.
We try, there's no doubt, but we can't. But we really are amenable to that, and really in most of the cases, that's going to be the best resolution for everybody, is if you can come to the table at the same time and think about the whole thing holistically. So
you're open to defense counsel coming into you and saying, I want to resolve this, but I also need to deal with Norway.
And I think it's domestically, we take the same approach. So I think in an ideal world, when you have multiple, enforcement authorities looking at the same conduct, first of all, one question we're asking ourselves is, should we be here? Right? And I don't think, you'll see us kind of glomming on at the end and saying, well, there's an alphabet soup of regulators that are settling. We kind of, why don't we put our hand out too? They'll pay us. I don't think you're going to see that from us. And likewise, where there are, investigations and, both there are multiple agencies there for good reason, I think our ideal approach would be figure out what the aggregate, resolution looks like, what relief, including what's the aggregate penalty, and then figuring out how that gets divided up among the various authorities. I can't say, as you know from the kinds of cases you've worked on, Pam, that's not always achievable because sometimes, there's a problem of, a multiple actor problem. But I think that's the goal that we set for ourselves.
In doing defense work, lawyers are often called upon to say, where am I going to get hurt most? And that comes up a lot in the data protection area. And often people would decide to get the SEC information, even if they might risk a fine in some jurisdiction. on a cost-benefit analysis. But on May 18th, we have the GDPR, the General Data Protection Regulation, coming in Europe that puts real teeth into the penalty that will be imposed. And it's a very restrictive law from the point of view of the U.S., and it does catch U.S. companies that do a substantial amount of work in Europe. Do you have a policy or program as to how to deal with the GDPR and what people should be doing in response to your requests?
I mean, it's a good question, and we're working with our Office of International Affairs to try to come up with some solutions that work. I mean, look, ultimately, we need to get the information, right? And so it's about figuring out what are the ways we can employ to do that, and how can we work cooperatively with others to get there.
Yeah, I think what I think is something that's hard for us to imagine is a system where important registrants and important issuers say to us, love to help you, but sorry, we've elected to store our data in France, and so you can't have it. That's not a situation that's particularly attractive from our perspective. So obviously, I think we're not going to, wantonly trot on, the rights of other sovereigns. But at some level, as Stephanie says, there are going to be cases where we need to get the information to accomplish our enforcement objectives.
I think from the defense bar, there's a concern that you will be open to dialogue on the conflict between the GDPR rules and what you need. And I guess we'll see in the next year or two where we are on that. Another issue of interest to the defense bar is obviously privilege. And the SFO last year got the High Court in England to basically eliminate privilege in a criminal investigation until the time there was a charging decision. Essentially, it's as if you were conducting an investigation and took the position that no notes or information is privileged until you issue a Wells notice. And that's put a lot of global companies in a difficult position, because if they conduct an interview in London, they know that that interview is not going to be privileged. And either they then have to give it to you, or they have to give it to the UK regulator. Again, is there some process for people trying to cope with the different privilege rules in the UK now, to any guidance or hope as to how to deal with the SEC when they've done interviews in London that they know are not privileged?
Well, I think some of this is an excellent question for David Green tomorrow morning. But I think, we can talk about our approach to privilege. Steph, do you want to,
Yeah, I mean, in terms of privilege, look, companies will often make the decision to cooperate with us and try to provide information to us. I mean, to be clear, we're not out there seeking privilege waivers on work product and that sort of thing. But companies will elect to provide that information. And look, it's in their interest and it's in our interest for a whole bunch of reasons, and it can really short-circuit an investigation in many ways. And so we're going to, continue to have that dialogue. But I think, for the most part, we're dealing with pretty sophisticated defense counsel who I think know what the risks are and have to kind of assess what those risks are. And it's not always sort of a perfect world. But I think, to the extent we can get information in whatever form that ends up sort of pushing our investigation along in a meaningful way, that's a better thing for all parties, right? So I'm not sure there's a clear answer on how this decision is going to ultimately impact what we do or how we deal with people, but we're certainly cognizant of it.
Yeah, I think it's sort of regular way for companies who conduct investigations that are cooperating with us to provide the results of those investigations in a variety of forms and methods. I would say it's very rare for us to have paper handed over to us, here are the results of this interview. But we regularly get briefed on the results of, key interviews and findings that are undertaken in an internal investigation. And I think, the most sophisticated counsel in the world are making the decision that that's, the risks of providing that kind of information are outweighed by the benefits of cooperation and the expediency in the investigation, et cetera. You do see some other, as people give us hypothetical answers, hypothetically, Pam Chapiga would say this if asked. frankly don't find that as helpful, and I don't think it merits the same amount of credit, but it's better than nothing.
Right.
And likewise, I know some lawyers have posited the idea of we'll just give sort of an amorphous presentation, not attributing facts to anybody, and I think that's the least useful, but again, it's better than giving us nothing. But the amount of credit that's going to be allocated for all those, I think, is probably going to be calibrated to, the ability to, assist us in getting to the finish line of whatever we're trying to achieve.
There was a recent decision in the Herrera case, which I think makes it even more difficult for defense counsel to come in and protect privilege while giving you a presentation. Have you seen change in the willingness of defense counsel to come in post-Herrera?
I don't know if we've seen a change. I mean, it's certainly something we are aware of, we talk about, we're thinking about. Again, I'm not sure. It's an important decision. I'm not sure how much it changes the landscape. I don't know. Do you have a different view?
Yeah. Look, I mean, it's funny. Upjohn was a case about a general counsel conducting a factual investigation and then being subpoenaed to provide the results of that investigation. The Supreme Court said that's protected. If you want the information, you can get it, but government, you've got to go to the people and interview them. You can't make the lawyer do that. Obviously, I think everyone in this room has probably done what Upjohn says you don't have to do, and I don't think that Herrera really changes that. It puts, obviously a fine point on the risks of, of there being a work product waiver.
I think everyone sort of always thought that was a risk.
Right. I mean, yes, it was an uneasy truce that
the
emperor now has no clothes, and we need to move on to some other uneasy truce, or just recalibrate the cost benefit.
Yeah, I think that's right.
Right. Cryptocurrencies. What are the challenges for the Division of Enforcement with all the emphasis now on cryptocurrencies?
Well, I mean, the challenges really are that it's become so hot, so fast, to such a broad degree, and so many people are either investing in it or trying to invest in it or trying to figure out how to invest in it. It really affects a broad population. And so, I think just the sheer size and scope makes it a huge challenge. Obviously, the technology is also something that, requires specialized knowledge and understanding. I mean, I would say we've really put a lot of resources into the crypto space, into the cyber space. Not too long after we became co-directors, we created a cyber unit, which, among other things, focuses on the crypto space, the ICOs, that sort of thing. Blockchain technology sort of is probably the broad descriptor. And so it's been a challenge for us. I think it's been one of the interesting things is kind of balancing the technology obviously has real benefit, right, and has real promise, and it's really about balancing. We're not looking to stifle innovation. We're not looking to stifle appropriate and lawful capital raising, and so it's kind of thinking about those issues. At the same time, our staff, who is already sort of amassed a wealth of knowledge in the cyberspace, but really becoming very educated in the blockchain and digital ledger technology space, and then really attacking this problem from all angles. And I think one of the things we've tried to do is really think broadly about how to attack this problem. And so a lot of it emanates from the cyber unit, but we have cyber liaisons in each of the offices. And so it really is a nationwide attempt to go after the problem. And while we're bringing enforcement actions, and we've brought a decent number of them already focused on fraud, fraudulent conduct, and the like, we're really sort of taking a very broad approach. And so we've done a handful of things. In addition to enforcement actions, we've made public statements, which is not something I think the divisions of enforcement's typically done, but we've made some pretty strong public statements on the issue. The chairman's made some statements on the issue. We formed a digital ledger technology working group, which has been in existence for a little while now, but that's sort of a cross-agency group, so it's not just enforcement, it's also experts in our Division of Corporation Finance and other areas, so that we're really thinking about all the ways the issues overlap in the industry, and then we're also working closely with our other counterparts, like the CFTC, Treasury, various U.S. attorneys' offices and the like. And then we're doing other things. We've done a lot of trading suspensions. We wrote a 21A report. We put that out on the Dow report back in July to really talk about when is an ICO or a virtual token or a virtual investment, when is it a security, when is it subject to the federal securities laws? So we've given that guidance. We've brought a registration case. And then, we've also done a lot of other stuff like outreach to companies that are planning ICOs and things like that. So sort of a broad answer, but it's an area that I think has a lot of challenges, but one that we've kind of really tried to approach very holistically and not just in one way.
Yeah. I mean, I think from an enforcement perspective, the issue presents kind of two broad categories. One are people who are just trying to take advantage of a newsworthy, it was medical marijuana, before that it was hurricane, disaster relief, before when I first started it was AIDS cures, whatever the flavor of the moment. And there are companies that are changing their name to add the word blockchain to it and and engaging in other kinds of, I think, completely fraudulent conduct. So that's one, put that off to one side. And then there's the registration issue, which is probably of less concern to people in this room, but people that are engaged in the sale of virtual tokens and ICOs, and we believe they're securities and they're being sold without appropriate registration or exemption from registration.
Insider trading, always a hot topic at the SEC. The Salmon decision came down last year. Has that had any impact on your enforcement program?
So I don't think meaningfully. Numan was decided, I guess, in 2014, and it's now with the Salmon decision and Martoma, both of its kind of core holdings have been abrogated. So I think we're kind of back to where we were before Numan was decided in terms of what the legal requirements are. But if you look at our insider trading program, it doesn't seem to have been impacted in terms of numbers and quality by the Numan decision. We brought some of the biggest insider trading cases in the Commission's history, in the wake of that decision, including the Newswire hacking case, the law firm hacking case, et cetera. It's a very important part of the program, and the thing that I was so impressed by when I came on board is how good the SEC staff is at it. I joked, I said, I thought Preet Bharara invented insider trading, but apparently not. We have incredible tools that have been developed in-house that allow us to detect across securities, identify common trading patterns, and we've developed on our own through data analysis, we've identified insider trading rings that have been prosecuted. And so we have a lot of people who are really good at this stuff, and I think it will continue to be an important part of the program.
Is there an intersection between the cyber work and insider trading? Because we look at insider trading in a way that I think didn't really take cyber attacks into account. Is that going to be a new area for insider trading?
I don't know if it's new, but it's certainly one of the areas of focus of the cyber unit. And so one of the things they're looking at is hacking in order, to obtain material non-public information, either to trade on it, to manipulate the market on it, to use it in some inappropriate way, illegal way in the marketplace. And so we have brought a number of cases that involve cyber attacks, hacking that resulted in insider trading, like the Newswire cases that Steve mentioned, like the law firm hacking case. There are some others. And then I'd also put in that same bucket kind of things like that are cyber, not necessarily hacking, but things like posting of false Edgar filings, false tweets, things like that also sort of require cyber expertise to sort of mask who's doing it and make it look real and those sorts of things and affect the market and sort of get some immediate term trading benefit. And so the cyber unit, I think, has done a great job developing and honing the expertise in really unpacking and unwinding those trades and transactions.
Yeah, and importantly, a core of people who are in our cyber unit were pulled out of our market abuse unit, which is the specialized unit that focuses on insider trading. So a lot of the people that had developed that cyber-related expertise are in the cyber unit now.
If there's any remnant of Numan, it might be in how far down the chain you're willing to go. Have those decisions been impacted by whatever remnants Numan has?
My own view is, Numan sort of shined because it was a rare situation in which you had a really remote set of tippies. I think there were 5th generation tippies in Numan, that it kind of highlighted the issue of what do remote tippies know about the circumstances of the original breach. I think those remote chains, those chains of long chains of tippies aren't kind of a usual fact pattern that we see. And I think there are always evidentiary challenges in establishing liability for people who are distant from the original breach and tip. And so I don't know that Numan, other than making clear that remote tippies have to know about the breach of duty and understand the existence of the personal benefit, and I think that probably does cabin off some remote tippies, but we're not seeing it come up on a regular basis.
Turning to the FCPA, the Justice Department has announced a program for corporations in which if they self-report, there will be a presumption of a declination. Are you considering a similar program?
I didn't really come to this job to decline cases. I came to bring cases. No, just kidding. I don't think we're going to have a program that parallels that. I think it remains to be seen. We typically in parallel investigations, we've typically sought disgorgement in FCPA cases, and the DOJ has obtained penalties. I think it's a good example of sort of the non-duplicative nature of remedies for two agencies that work obviously very closely together in a particular space. What happens in the decline cases, I think that remains to be seen. Whether if the DOJ has declined and we've obtained disgorgement, will we be considering seeking a penalty in those cases? I don't know. I think that remains to be seen. But I don't expect us to have a declination program like the DOJ's program. And there are good reasons for that. I mean, the criminal prosecution carries, sanctions and collateral consequences that are dramatically different than an SEC enforcement action. And so the cudgel or the stick that they wield is a heavier one than the one that we wield. Steph, I don't know if you have
No, I
any
think
thoughts.
totally agree.
Whistleblowing. You've gotten a lot of cases out of your whistleblowing program, and it's been very successful. And you had an interpretation of the anti-retaliation provisions of Dodd-Frank that was quite broad. Last week in Digital Realty, the U.S. Supreme Court disregarded your interpretation of Dodd-Frank and substituted its own more literal reading of the statute to narrow the availability of protections to whistleblowers. Do you think this will have any impact on the whistleblowing program?
I think, look, it remains to be seen what the impact will be, but it's got to, right, to some degree. It feels like it should, and it seems like, the most likely impact is that people report to the SEC sooner, or at least contemporaneously with reporting internally if the protections are something they want to make sure to avail themselves of. I mean, I see that as being a potentially natural consequence of the decision. And the program has been incredibly successful, and the number of reports we get truly increases year over year. I think last year we had roughly 4,500 whistleblower tips come in, and we have probably 700 or so cases right now that involve a whistleblower in some way or another. So it's, it's not like we don't already get a lot of reports, but to me, that strikes me as kind of the natural consequence. I don't know.
I agree.
And are you seeing any pushback from in-house corporate compliance programs? Or do you think there's resignation that the Supreme Court has spoken and there's not much they can do?
I don't know.
I think it's too soon.
Right?
I think, look, there's been rulemaking to try to incentivize internal whistleblowing. That our program, that the benefits of the whistleblower program can still be obtained, notwithstanding internal whistleblowing. And I think, as Steph says, Digital Realty may shift that slightly, but I think it's still only a few days old, so we'll have to watch the space.
Do you read anything more broadly into the lack of Chevron deference the Supreme Court showed in its Digital Realty opinion?
I don't really get
Yeah, I don't know. That may be a question for bigger brains than mine, but they took a very, as you point out, they took a very literal reading of the statute, and I think that's kind of all you can really glean from it at this point.
Okay. Speaking of the Supreme Court, the administrative law judge issue has finally percolated itself up to the Supreme Court in Lucia. We'll have a decision this year. Yeah. What do you anticipate, and your position, I gather, has changed with the change in administration between the Circuit Court and the Supreme Court?
I mean, I think given the status of the litigation, there's probably not a lot we can say other than obviously the decision will impact the program in some way, kind of remains to be seen what it is. The commission did ratify the appointment of the administrative law judges a couple of months ago now, I think. And I think just in terms of the program, generally in the use of administrative proceedings, I think we've continued to file litigated administrative proceedings, but obviously all the ongoing litigation puts a lot of things into uncertainty and creates risk. But I think if you look at the cases we've generally been filing as litigated APs, they're almost entirely some combination of against registered entities, so registered broker-dealers or investment advisors, registrants that have always been subject to the use of administrative proceedings. And cases where really the charges of the relief that we're seeking can really, or the principal relief we're seeking can really only be really gotten in administrative proceedings.
So maybe familiar to some, but there are some kinds of relief and some claims that we only have statutory authority to obtain administratively.
I forgot it's not an SEC crowd.
So for example, a proceeding under Rule 102E to bar an accountant or attorney from practicing before the commission, we can't really get that except administratively. And so recently we brought a case against current and former members of the Public Company Accounting Oversight Board and partners of KPMG. It involved the leaking of confidential information to KPMG relating to the PCAOB's examination. That case we brought administratively because the principal relief we're seeking there is to bar those accountants from practicing before the commission, and it doesn't make any sense to bring that case in federal court. So those are the kinds of cases that we're continuing to bring administratively, and obviously, we're anxious to see what the Supreme Court says, as are others.
Some of the members of the defense bar think it's somewhat ironic that the way Lucia has now gotten to the Supreme Court is really more about who has the right to hire and fire administrative law judges than about the amount of due process one gets in an administrative law proceeding. Do you see changes in the administrative law proceedings to whatever extent they are going to be authorized to continue?
We just don't know, but go ahead.
Yeah, I mean, the commission took some steps to try to modernize the administrative proceeding rules, giving some expanded discovery rights, expanding the time frame in which they have to be conducted. They're
Dispositive motions.
Dispositive motions. They're obviously different, though, than the rights that are achieved or obtained in federal court. There is a cost to litigating in federal court for us in terms of the speed of resolution. And there are some times when it's really in our ultimate agency interest to get relief quickly. The administrative process provides that relief more swiftly than we could obtain it in federal court. But I understand and totally appreciate that if you're a litigant, there are some things that you can't do in an administrative proceeding and that you can do in federal
district
court.
Although there are some things you can do in an administrative proceeding, right? Like
we have open file discovery, for example, administrative
We have
proceedings.
Brady obligations, we have Jinx obligations.
So I don't know whether there will be further changes. I don't think it's good. In general, I don't think it's good for there to be any perception, real or imagined, that the administrative process is not a due process. And administrative tribunals are a feature across the federal government. We have, somebody pointed out, we have 5 administrative law judges at the SEC. The Social Security Administration has 1,200, I think. So we're a little bit, although we've been the forefront of this issue, we're a little bit of a tail wagging a bigger dog here.
On the last panel, one of the general counsels guesstimated that there was going to be a lot less work for people in this room post-financial crisis, that we were in a bubble of enforcement. What do you plan to do to provide more work for people here? What's on your to-do list?
So I guess a couple of observations. First, we're going to work late every night. But beyond that, look, one thing that's kind of surprised me upon coming into this job was a lot of the misconduct that I saw as a prosecutor in 2000 is still going on. We still have lots of microcap fraud, Ponzi schemes, offering fraud, insider trading, all that stuff. And that, regardless of what the economic climate is or what party's in office or who's in the commission, et cetera, that's 80% of what happens at the SEC, maybe even more. And then the question is, what do you do around the margins? I think there's going to be, for example, our focus on cyber is going to result, I think, in a lot of activity. But we're not slowing down. We haven't received any such directive, and we're trying to, do as much, be as productive, and be thoughtful about what we're doing.
Yep.
Any topics we haven't covered that you think you would like to talk about?
No, I think we want to get out of here without causing any problems.
It's always a white knuckle ride, I say.
Well, thank you very much for coming. It was very generous of you to give us some time.
Thank you.